Hello, my name is David Height, and I am the Director of Debate at the Carrollton School of the Sacred Heart. I'm here to talk to you about being negative against the Patent Eligibility Restoration Act affirmative. I wrote both the affirmative and the negative file that you have in the novice packet. I think that there are very strong arguments that the negative can say. I'm not going to talk about every argument in the negative file. I'm going to highlight some of the arguments that I think are the most important things that you should be talking about on the case. It doesn't mean that I don't think the other arguments are not important, and in some debates, those you may want to focus on some of those other arguments. But these are the arguments that I think should probably be prioritized against this affirmative. I will also talk about the disadvantage that is in the negative file and the counterplan that is in the negative file. One other thing to note is that the three disadvantages that are in the novice packet that are not part of the PERA negative file, so the inflation disadvantage, the court clog disadvantage, and the AI disadvantage, all of them link to this affirmative, and they are all very strong arguments against this affirmative. So while I'm not going to be talking about them because you have separate files for them, I'm only going to be talking about the arguments within the case negative file, but I do think that those other disadvantages are very useful. Okay, so the negative arguments against the competitiveness advantage. There are a lot of arguments that you can make here. I think they're all good. I'm only going to talk about one of them because I think one of the first argument on that advantage is the strongest argument by far. So this argument says that the United States is winning the technology race against China now. The entire advantage says it's bad if China wins the technology race, if China displaces United States leadership. This argument says that China is not winning the race and will not win the race because the US is actually doing just fine. So there are two arguments that I think are worth pointing out from the 1NC evidence that makes this claim. Number one is that predictions about the United States falling behind in technology have been made regularly since the 1960s and they have never been correct. Why is that true? We'll address that in a second. Number two is China's advantage in 37 of 44 technologies, which is what the 1AC says, does not explain why the United States remains the leader in the technologies that really matter. So AI technologies, the United States is ahead. They develop things like OpenAI and ChatGPT. The United States developed the COVID vaccine. The United States regularly turns out innovations that that the rest of the world doesn't really reach. So the statistic of 37 out of 44 technologies raises the question of how are you measuring that China is ahead in 37 out of 44 technologies? And why are the predictions of China being ahead of the United States or the US falling behind other countries so consistently wrong? And that has to do with that patents are not necessarily the best metric in determining the level of a country's technology. So it is true that China and Europe issue more patents than the United States. But there is some negative evidence in the extensions that say that Chinese patents and European patents are of lower quality than the United States patents. So the technologies that those patents are taken out on just don't really do anything or have like really low significance in terms of like how important they are to really high-tech innovations. So this argument essentially defends the status quo and says the metrics that the affirmative is using to assess whether or not the US is ahead or behind are just wrong. And there's even evidence that says that there are a lot of other metrics outside of patents that the US is unambiguously ahead on, like the level of research and development spending. That's what R&D means, research and development spending, and the level, the nature of the entrepreneurial culture within the United States, the fact that there are very few regulations, that it is a free market, the availability of skilled labor. All of those would matter more than the number of patents being issued in terms of the overall effect on United States competitiveness with other countries on United States technological leadership. For the innovation advantage, I'm going to highlight, I think, a couple more arguments. So One is that innovation is already very high in the United States. So the premise of the affirmative advantage is that startup investment in startups is decreasing. We have evidence that says that that's not really true, that startups are increasing. They're attracting new venture capital investment. Even if they don't have access to patents, they're still doing very, very well. Then the second argument that I would highlight is a patent trolls term. So patent trolls is a pejorative term. So it was basically a term that was, I think, coined by big tech companies like Apple and Microsoft to essentially try to influence public opinion against patents and against software patents in particular, because Apple was like facing a lot of infringement suits where Apple said these are really low quality patents. These patents shouldn't really exist. They're made by patent trolls. The non-pejorative term to talk about a patent troll is to say non-practicing entity. So it's essentially, it refers to a law firm that doesn't own the technology, but they bought the patent from the inventor, and their entire business model relies upon them suing infringement, finding people that they think are infringing and suing those people, and then giving the inventor a portion of the proceeds, but the law firm makes all of their money from those lawsuits as well. And the claim that the negative would make is that the reason why the 4 Supreme Court decisions under Alice Mayo even exist in the first place is because patent trolls used to be a big problem in 2010. Before the Alice Mayo decisions came out, patent trolls were a big problem, especially in software, and the court decisions are something that reduced the instances of patent trolls by reducing the number of bad patents that were issued by the U.S. Patent and Trademark Office. So it would claim that increasing eligibility or making eligibility more easily to meet the standard for eligibility will return us to a world where there are a lot of bad patents that are issued, and patent trolls will vigorously enforce those suits, even though they're over like really small or silly things, to extract more money from innovators, and that will reduce the level of innovation overall. The third argument that is in this file is similar to that. Well, it's not the third argument in the file, but the third argument I want to highlight is called patent thickets. Patent thickets refers to the fact that in some sectors there are so many patents that exist for a particular product. So for example, like the iPhone or smartphone has thousands of patents associated with it. And there's so many patents that it makes it impossible for a new innovator, a new market entrant, a new startup company that has a good idea, it makes it impossible for them to actually innovate in a cost-effective manner, because in order to break into the market at all, they have to pay licensing fees to potentially dozens or maybe even hundreds of different companies for all of the patents that they would have to license before they could even start creating a new product. So essentially, the argument is that if you make patents easier to obtain, but if you increase the number of patents that are eligible, then you increase the chance that more bad patents are taken out. That will increase the risk of patent thickets and reduce the overall level of innovation. Okay, so there's also a disadvantage in the file called pathogen patents, and this disadvantage I think is quite good. There are some weak points to it, but overall the quality of the evidence for this disadvantage is very, very high, and I think it is definitely capable of beating this affirmative. So this argument says that the plan, by overturning the Myriad decision, so the Myriad decision is one of the 4 decisions that in the Alice Mayo framework. So the plan overturns the Myriad decision. Myriad was a decision that said that you could not patent genes. So gene patenting was off the table. It was actually, the Myriad case was about whether or not the company Myriad could patent a gene for breast cancer, and whether or not they could create a diagnostic tool based upon that gene, and the Supreme Court said no. So this disadvantage essentially says by overturning the Myriad decision, that allows greater patents on genes, and gene patents undermine research to stop disease. So to give you an example, during COVID, there weren't patents on genes because of the Myriad decision. The Myriad decision came out in 2014, and developing the COVID vaccine was the fastest vaccine that was developed, I think, in history. It was based off entirely new technology, mRNA technology, that involved a lot of international research cooperation that was important to developing that vaccine. So even though COVID caused millions of deaths globally, the impact to it was a lot less because the vaccine was developed relatively very quickly. But in contrast, before Myriad, so like a series of pandemics that occurred in the early 2000s, like the Ebola pandemic and H5N1, there were actually companies that tried to patent genes from those diseases, and it reduced the amount of international cooperation. And the primary author of this disadvantage says that the reason was because gene patenting was legal, that reduced incentives for international research cooperation, and therefore the ability to develop a cure or a vaccine for those particular diseases was much, much slower, and as a result, the diseases were much worse than they otherwise could have been. So this disadvantage would say, the uniqueness to this disadvantage says that international cooperation on disease research is increasing and it is unfettered by patents. The uniqueness evidence is quite good. It says that because of the Myriad decision, there is greater international research cooperation on emerging diseases, and it means that if there's a new pandemic, something like COVID or something worse than COVID, that we have an infrastructure in place that allows us to quickly research it and hopefully develop a vaccine or a cure. The link says that patenting genes makes it harder for countries to cooperate to prevent pandemics. So to work on developing a cure requires mapping the genetic sequence of a bacteria or virus, but if companies or countries are trying to block that cooperation because of genetic patents, then that would delay that research. It might not stop that research, but it would mean that the speed of the response would be much slower, and the slower you are in terms of responding to a disease, the more people that would be infected and the more people that would probably die. The impact of this disadvantage, I think, is the weakest part of the disadvantage. I actually think the uniqueness in the link is very, very strong. The evidence quality for it is very high, and a negative team that invests a lot of time in explaining these arguments and reading the appropriate evidence for these arguments should be very successful. The impact is weaker, mainly just because it's inherently probabilistic. It's like we don't know when a future pandemic is going to occur. We don't know what it could be like. However, the negative evidence does make some arguments that I think are somewhat difficult to answer, where it says that future pandemics are probably inevitable just because of the nature of like globalized travel makes disease spread really quickly, and that it is possible with either mutations or deliberate engineering that future diseases could be a lot more lethal than what COVID was. So COVID was lethal, millions died, but it wasn't like the overall lethality rate of it was in the single digits. It was like, something like 1 to 2% of people infected, died. But the reason why it still killed millions was it was unprecedented in terms of how fast it spread. So some of the impact evidence here says if there was something that was like COVID that spread as fast as COVID but was a lot more lethal, then the impact would be catastrophic. The evidence claims that it could wipe out the human race. That is an absurd claim. Sometimes debate evidence makes arguments like that. We have incentives to talk about the worst case scenario. It's probably not possible for a disease to wipe out the human race, but it is definitely possible for a disease to have a much worse impact than COVID. And there is some evidence in the file that talks about why that impact would still be catastrophic. The last argument I will talk about is called the prizes counterplan. A counterplan is an alternative policy proposal that tries to solve the affirmative but doesn't use patents, or at least this counterplan doesn't try to use patents. So it claims to have a superior way of increasing innovation and competitiveness, but says that that is a better way because patents are bad. So the counterplan depends upon you both proving that the counterplan solves the case and proving that patents are bad in some way. Patents can be bad because of patent trolls, because of patent thickets, because of the pathogen patents disadvantage, or because any of the other three disadvantages that you have in the novice packet, because they are all specific to patents. And the prizes counterplan does not use patents at all. So it says that it can solve the case, but avoid the disadvantages, which would make it the better policy option overall. The argument is that instead of patenting something, the government should give prizes to new inventions. So for example, if the government wants to develop a better way of environmental remediation using microbes, which is what the Advantage 2 is for the PERA app is about, if the government wants to do that, it doesn't have to give patents for that, for new microbial environmental remediation. Instead, it could hold a contest and say, basically publicly say, for whatever company can demonstrate over a period of years that they have the most innovative or the most effective form of environmental remediation for chemical pollution, they will get a prize that is, valued at what a patent might be valued at. How do you calculate the prize? It's a little bit difficult, but some of the evidence describes how this might occur. So for example, you could calculate it based off the sales value of the product after the product has been sold. So the winning company gets a prize for whatever they think the value, or whatever the government thinks the value of that patent is, but then they might in subsequent years get additional payments from the government based upon the number of products that were sold in the market, to compensate them in the same way that a patent might compensate for them. So the principal difference between prizes and patents are that with a prize system, the government is paying for the innovation. With a patent system, the government doesn't pay for the innovation. They give a patent, but society pays for the innovation because the patent allows a company to charge higher prices through monopoly pricing. They can't charge higher prices under a prize system, mainly because they don't have a monopoly. Anybody can sell the product, but the government would nonetheless give them monetary payments if their product was selling well and if their product was socially beneficial, if it was connected to any of the government policy objectives that the 1AC is talking about. So essentially the prizes counterplan, there's evidence that says like prize systems have worked in the past to boost innovation, to boost competitiveness, and it is a very powerful argument against the patents act. There are very good affirmative answers, but there are also really good negative responses to it. So once you start learning about counterplans, it is definitely worth your time to invest in some in preparing this counterplan, because it is a pretty successful argument against the patents part of the topic. So I hope that you have fun debating the patents area. I think the affirmative and the negative is really good. So I hope that you enjoy this area of the topic.